Okay. All right. Hello, everybody. Hello. I'm running very late or early. Depends. We don't even know anymore. Is it early? Is it late? Who knows? Oh my gosh. All right. Well, welcome in. Welcome in. I'm still getting my stuff set out here. So I just need a minute. But good morning. This is morning for me. Maybe not anybody else, but for me, this is the morning. And I figured we're going to need some additional lives here over the next week in order to catch up because there's so much stuff going on. All right, I'm picking my rings out right now. Let me see, what do I want to do? It takes some time. Hello, Lisa Beth Slave. I'm sorry, Lissa. I'm in the Central Time Zone, so I'm in the middle of the United States, where you know the sticks are. There's a lot of sticks out here. Good morning, Nada. Good morning, Jennifer. Welcome in. Welcome in. Yeah, I just wanted to. I'll probably be doing a couple of extra. Lissa Beth. Okay, thank you so much. I appreciate that. I have a friend named Laura, and she says her name's actually Laura, and I have been calling her Laura for 10 years. My bad, my bad. Hello, Ellie. Welcome, welcome in. Yeah, so come on, come on in, everybody. My apologies on that. You were on one of the coasts. Oh, yeah, I wish, Don. I mean, if dreams would come true, yes. But alas, no. I'm in the middle of the United States in a red state. Well, I mean, middle-ish. So the Hubs and I we grew up in this little teeny tiny town. Fell in love with the town because, and we stayed. We don't have anybody else here though. Nobody else stayed, understandable. But like at Christmas time, all of our friends from all over come back in again. We're like, hey, where you been? How's it going in the blue states? So, yes. All right. So this one's silver here. Hello, Biron. I hope I said that right. Baron. Hello, Toodle. You got a teeny tiny town too. I love it. I love it. I shouldn't say my town is that teeny, but it feels teeny after living in places that were not teeny. How's that? Oh, here we go. Found one. One of my favorites here. Hello. Hi, Mika. Welcome in, everybody. So, for those of you that have been hanging out with me, I have not been on for just a couple days actually, but I'm back now. Fingers crossed. So, last night, for those of you that joined, I do have if you're wondering, I do have a lozenge for my throat, and so I'll try to not have lozenge sounds for the Mesopotamians out there. Hello, True Blue. Hi. Put me to sleep last night. Ooh, I know, right, Shauna? So I know, same. So today, what I have is I would like to just read one or two of these letters that are included in the use of force policy rather than going through the full policy. So we'll catch a couple of these letters, I thought, today. And then what's more fun than ethics? Nothing. So I thought we would probably catch one of these rules as well, just to kind of, see what's going on. What are the rules? What's supposed to be done here? I do have some other pieces that I do want to add as time goes on that include the Hague and include other countries and what their requirements are versus what we're doing, right? So we've got the Hague in here, London in here, mostly the Hague again in here. So when we're dealing with some international questions for the Geneva Convention and such, I do have that as well. I thought that would be fun. 3.4. Really? Okay. Okay. Yeah. Oh, we do love the Hague. We really do. We're like, dear Hague, do you mind? We wanted to show you something. Oh my gosh. All right. So that's kind of what I was wanting to take a look at today. We did do some, again, we're kind of piecemealing this from different things because I don't think everybody enjoys reading a catalog as much as I do. So, yes, absolutely. Is it crazy today? Really? Oh dear. It's been kind of bonkers recently. So, but hopefully the bonkers will calm down because we don't need any bonkers right now. Life is bonkerish enough, right? All right, so there we go. Coming in hot, 2029. All right, let me get a sticky note here. Set out. So we're just doing 2 letters in the policy here, and then hopping over, we're going to look at some ethics rules here. We're going to look at some attorney ethics. I've done this before, and I've done a couple of posts on it. So I think people have some idea of what's going on, but I think it's always great to kind of walk through it a little bit. Is it? Now, wait a minute. Junior, happy Friday. Oh my goodness gracious. I really thought for a moment that it was Friday. It's like, what? It does happen. So yes. All right. So let me put this up here. We've got the Border Patrol here, use of force. Now, of course, a lot of people last night, and rightfully so, is saying they're not paying attention to their own rules. They're not following what they need to follow. And to that I say, you're probably right. But we must remember, for every single situation that's occurring, if we've got a violation of federal law or a violation of the Constitution, and here, these are not federal laws, but they're policies, which means they still have to follow these. And if they're not, that's where the lawsuits come in. So all we have to do is to show that they were violating their own policies, and then we can keep moving on. And in a ton of situations, they're violating it. So even with just one person, if we're talking about the tear gas stuff, it's like you did this, it was against your own policy, you did this, and this. And that's how you move your civil case forward. Do we want to have a whole bunch of civil cases? No, but it's what we've got. You know, that's kind of what we've got to try to check some of these. Yes, VC, exactly. They will. The courts will. And the thing is, too, we're kind of all tangled up in this orange mess because of the orange supporters. And I mean, I didn't see all of the little fella, what's his name, Mikey, stand up and saying we don't want to do like proper affidavits and probable cause in order to get a warrant to get somebody. We just want to be able to grab them off the street. So that little fella out there saying stuff like that, he's a lawyer. He's a lawyer. I do not know which state he is licensed out of. I'm going to assume Kentucky. But for him going in and saying that is a violation of our ethics rules, right? So that's kind of good too, right? We're like, hey, little fella, you just violated your own ethical rules. Is that where he's at? Takes too much time. Yeah. How do the cops feel, right? They're coming up on a homicide. They've got like no time to make these very important decisions. Meanwhile, these fellas and ladies, I don't know if I've seen any, too many ladies out there, but you know, they're just like, la, 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 let's go tap your car. So I'm not trying to diminish the role of Border Patrol, but I am going to say they're out of control, in my humble opinion. So, yeah, he's in Louisiana. Okay. I don't know if it'd be, great question, Baron. I don't think we can get all the way to disbarment, which is hard for any situation. I mean, you got to be way, way out of control for disbarment, and people getting hurt, crimes being charged. But you could possibly lose your license for a period of time. When you get up there, and there's multiple rules that he violated, just multiples. We'll take a look at that too today. Really? Oh, she pepper sprayed herself. Oh my gosh, right? He's out of control. I agree. I think Johnny got some footage of that too. And, I'm just, I don't feel comfortable giving too much information out on stuff I don't really know about. But when you see it with your own eyes, it's like, what just happened here? Having a hard time today. It's also heavy. Well, we're going to break it apart. If you break apart something, it's easier to carry because you get a little piece and then everybody else has to carry their own. So here we go. We're going to look up some letters here that are going to tell us how this is supposed to be done. So this is the Border Patrol use of force policy. We also have a home security basic training, Homeland Security Basic Training Handbook here as well. So all of the actions of the cubes of Homeland Security of Border Patrol, all of their actions are out of these policy manuals. So if they are doing stuff that's not allowed, again, not allowed here, they are violating their own policies. When you violate your own policy, you get called out on it, right? And they call you in to say like, dude, what are you doing? Now you might say the leaders don't really care. True. But you know who cares? The courts. The courts care a lot. That is, of course, I'm happy to be here. One of the first things when I was prosecuting did I do it more as a prosecutor or as defense counsel? That's a tough call, actually, because I always included when I would question law enforcement, I didn't care where they were from, if it was whatever. The questions would be, are you a certified peace officer? And they would say yes. Where did you get your certification? They would set it out. Does your particular location have standard operating procedures? Yes. And did you read those? Yes. And did you violate those? Yes, I did. So that can be very important in turning a case, is whether or not they violated their own rules. So this is just to put everybody to sleep. All right. We might fall asleep. Table of contents we did last night a little bit. We were jumping around a bit last night. We had a lot to cover. So safe tactics, we talked about that. The manual itself really isn't that large. It's just, but there's a lot added, like the glossary and such. So a lot coming in here and explaining use of less than lethal force can be used. Of course, they've got all these, whatchamajiggers on their different stuff. I don't even know. Their vests. I mean, is a vest? I don't even know anywhere. But there's all this stuff on there. And in that stuff should be a less lethal means of taking someone down, right? Along with security and such. You're supposed to be taught this. You're supposed to be taught what to do that doesn't lead to someone being unalived. Oh my gosh, thank Grandma. Sometimes, for some reason, I go back to the 1930s. Whoops the daisies there, like I can't even control it. All right, and then we have vehicular immobilizations here where they talk about hot pursuit, which is one of the exceptions to the warrant clause. If it's done right, if you mess it up, then you can't use it. So that's here. We're going all the way to the back here, everybody. Here we go. So what I wanted to look at here, just a couple pages, and this is the most up-to-date that we have right now. Now, in August of this past year, I believe they did update the Department of Justice stuff, but I have not seen an update here to these letters for Homeland Security since this one was done in September. Cover comprehensively in 47 days. Well, that's a good point. And absolutely, I agree completely. The other part of that is, what are you focusing on? So if ever my class, typically I would teach 50 minutes 3 times a week, but there were a couple where I would do evening classes, and those were like 3 hours once a week. But the problem is when you chop it all up, then the person teaching it has to say, like, what are we not going to talk about? Are we not going to talk about the rules because we don't have time? Or are we not going to talk about the procedures or how to take somebody down, the physicality piece. And that's tough. Yeah, skip the, I agree. Oh, you're so sweet. So these are, oh my gosh, I forget it every single time. Every single time I forget it. Oh no, they're like, a silver box. And it's like, the name starts with an I, but it's not insurrection. Oh my goodness. So these particular ones, I do not know. I ordered a whole batch online, and so sometimes when the seasons change, then a lot of them go on sale. But no, not Imani. It's like it sounds like insurrection, but it's not. It's close. It's close to that. All right. I'm sorry. I told myself I needed to bring my box up with me, but I was worried that the TikTok would get angry. So, Inception, is that one of them? June Marie. Hey yo, what's up? What's going on? Not the insurrection nails. I know. I don't know what's happening, everybody. I'm sorry. Like half of my brain's like, what's going on in the world? The other half is, let's do this. So, half and half here. Oh my gosh, I'll have to bring it up later. Sorry. Impress, no, that's the Kiss ones, which are great. We love those. Anywho, well, thank you very much for Valentine's Day. Yes, so I do have a couple of sets of insurrection nails. All right. Here we go. Let me dive in. Oh my goodness gracious. Here we go. Let's have some fun talking about the end of democracy. Kidding. Just kidding. All right, DHS policy on the use of force. So here we go. Homeland Security. This was set into place in 2018. I've not seen, as I was saying, I've not seen an updated letter from Homeland Security. I don't doubt one is coming, but everything's a mess when you only trust 5 people to run the entire federal government. Things get lost in there, so... Really? Oh, that's nice. Oh, I think that's great, everybody. I've seen so many people now with such fun nails. I just love it. I think it's just fabulous. Right, exactly. Yeah, I do have the claws out still. And, too, I have one pair of Cheeto fingernails. I'm saving them for a special occasion. Here we go. Let's dive in. Use of force. And these are letters again. So, memorandum here from, looks like Grundy, I guess. I don't know, but then it's signed by someone else, so we'll skip it. Here's the policy. So, number 1, purpose. And this is pretty messed up writing. I'm going to get one of my other sets of glasses here. And see if that helps a little bit. Sometimes I have to layer my glasses. Right. I don't know. You see, but that's funny. Not sure about that one. All right, purpose. Pursuant to the Secretary's authority under Title VI United States Code, Section 112, this policy articulates department-wide standards and guidelines related to the use of force by Department of Homeland Security, so DHS, law enforcement officers and agents, and employing LEOs. Let me make sure I'm getting this right. This is a little bit difficult for me to actually read here. I apologize, everyone. Let me see here. And... there we go. I skipped a line. Affirms the duty of all DHS employees to report improper use of force. All DHS components employing LEOs are directed to implement this guidance, including investigation and documentation practices through component-specific policy, procedure, and training. Right. All right. Yeah, I know. No, I'll get in there. Hi, Fish Taco Guy. Welcome in. All right, this memorandum supersedes the memorandum from Secretary Tom Ridge, Department of Homeland Security Policy, on the use of unalived force, which had been put into play June 25th of 2004, which would have been Obama. Is that right? I think. Oh, great. Very good. A documentary. Oh, that sounds very interesting. Right. Report to their colleagues. Yeah, it's pretty. Ugh. So I'm going to guess this was Obama, but I'm bad with math, but it got replaced. And then you can see here even, we're in 2018. So we're not even all the way back up to, was it Bush? Okay, thank you very much. Thank you. Appreciate that. So it wasn't all the way back as well. So they're going to need to get another one sent out. They're probably going to just tweak the Department of Justice one that they've sent out. But who knows anymore what they're going to do. Maybe they'll put it on a carton of yogurt and tell the judge, oops, sorry, it's spoiled. I can't read it. Number 2, use of force standard. Introduction here. In determining the appropriateness of a particular use of force, the department is guided by constitutional law. Well, that's refreshing. As interpreted by the U.S. Supreme Court, not as refreshing, because we all know what they're doing, because they're crazy. So I will bop down here. We've got the Graham v. Connor case and the Tennessee v. Garner case. And these are the biggest cases when it comes to use of lethal force. This is where there was a kid who was running up and over a fence to try to run away. And then the Graham v. Connor case, for some reason, is completely, my mind just has let go of it. But both of these are very, very important cases with Supreme Court landmark decisions here. So Graham v. Connor and then Tennessee v. Garner. That's going to bother me all day. I'll probably have to look that up after the live. Like, what? This was 1989. I shouldn't have forgotten that one. The Fourth Amendment supplies a constitutional baseline for permissible use of force by LEOs in the course of their official duties. Law enforcement agencies may adopt policies that further constrain the use of force. This policy describes the governing legal framework and articulates additional principles to which the department will adhere. This is a bit weird. Yeah, it was 1989. I just can't remember any of the facts in that one. Sometimes, the cases, they leave my memory. This is really weird, in my humble opinion, but yet put out in all of these different policies. So this isn't something new, but this is weird where they're coming in and saying, we're going to follow the Constitution. Well, all right, but what does that even mean? You've got 2 cases here that give some structure to what we're looking at, but not enough to really assist in that kind of situation. Our Supreme Court case just don't do that. They just don't. The only time, honestly, I've ever seen a Supreme Court case like hit the ground running, meaning it needed to be done immediately, was Brown versus Board of Education. I think those cases were, once they hit the ground, that segregation was no longer allowed, it was like whoosh throughout the rest of the U.S., but I've not seen other cases that do that. So here they're just like, we'll comply with the Fourth Amendment, whatever that means. They must have thought he was, oh, really? He was in a diabetic, emergency. Oh my gosh, VC. Is this the one where he went to the gas station to get some orange juice to help his situation? And like things just got out of control. This would be the orange juice case. Oh, good, VC. All right. I remembered at least the orange juice. Right. So he was trying to help himself. He was going through a diabetic situation, and he was with a friend, if I remember, and trying to help with that. And then they just didn't care. They just went to town. He had some major issues going on there. Oh, yeah. Yeah. Right. Objective reasonableness. Yeah, that's a tough one. Those terms don't really go together that well in the legal field, although in my opinion they should. General statement. So here's our introduction. fine, we'll pay attention to the Fourth Amendment, whatever that means. And then B, general statement. Also, the Fourth Amendment is the most litigated amendment in criminal court. The search and seizure element, along with the warrants clause. Also, under the Fourth Amendment and Fifth and Sixth, that's where the Miranda rights click into place as well. So this is a big one here. To get better, and they stopped him and right. That's pretty sad. Dozens of regular, really? Wow. Oh my gosh, I don't doubt it, Carol. I don't doubt it. So here's B, general statement. Unless further restricted by DHS component policy. All right. DHS LEOs are permitted to use force to control subjects in the course of their official duties as authorized by law and in defense of themselves and others. In doing so, an LEO shall use only the force that is objectively reasonable, right? Whatever that means, in light of the facts and circumstances confronting him or her at the time force is applied. So when we're going down that objectively reasonable rule, what we're really meaning in court is that we have to prove that an officer with the same amount of, thank you everybody, oh, I appreciate that, with the same amount of training and education would make the same decision if he or she was in the shoes of the officer that did it. So that's key here. We can't say any officer, we have to narrow it down to any officer with the same training in that situation. All right, that gets a little bit weird though, right? Because we don't know, we don't know exactly how much training and such he has or her at the time. And let me clarify too, I may say he quite a bit, but there have been a few women cops or law enforcement who have also gone down that road as well. But I've not seen excessive force. I'm not seeing an excessive force case. Not saying there won't be one. I'm just saying I haven't seen it. And I'm out in the sticks, so we don't get all of the crime out here. All right, here we go. This is the last piece that they're adding here. So C for discussion. The Fourth Amendment reasonableness standard, which is just ridiculous. The reasonable person standard, the reasonable doctor standard, we use this reasonableness standard, but we don't define it. It's not defined. And in fact, I believe when we started using reasonableness, Terry v. Ohio, which became the stop and frisk case, super old, but I think Time had published a magazine. I know magazines are like old school. Look it up on the Google. But the Time had put in, I think it was Time, the story trying to define a reasonable person. And at the time, it was old school. And so they said a reasonable person had Campbell's tomato soup with grilled cheese sandwiches, on Sundays mowed the lawn in their shirt sleeves, whatever that is, and always went to church. And so they had all of these different qualifications to set what a reasonable person was. And that was great, but it's not true. We just don't know until we get into the case. It's case by case reasonable. Like highlights. Oh my goodness. Oh, that's funny. Yes, like highlights. There are a lot of unreasonable people. And this term and the reasonableness is what gets used quite a bit. It's what we're arguing about in court, right? Was this reasonable? Would a reasonable person put a curling iron in a toaster oven and toss it into a bathtub when it's connected? Those are the questions we ask. Would a reasonable person do that? And so that standard has to get flushed out. We need soup. Yeah, that's what it was, according to the article. Again, that article was also written a long time ago too, so it's been updated, I'm assuming. All right. Yeah, these days. True. So here we go. That reasonableness again term is going to be used constantly, and it's the one that we really can argue in court, to argue to say what our client was reasonable. They responded reasonably, and if anyone else had been in that situation. Number one, the Supreme Court has ruled that all claims that law enforcement officers have used excessive force, unalively or not, in the course of an arrest, investigatory stop, that's a stop and frisk, or other seizure of a free citizen should be analyzed under the Fourth Amendment and its reasonableness standard. And we'll pop down here for footnote number 2, which states the Graham case. The court has further determined that a Fourth Amendment seizure of a person occurs when an officer, quote, by means of physical force or show of authority, terminate or restrains his freedom of movement through means intentionally applied. So they're quoting also, this idea of what's an arrest versus a seizure, right? Because if you're in the situation, you're like, am I being arrested? They're going to be like, blah, blah, jelly donut. But if you're like, am I free to leave? Am I free to leave right now? And they say no, then you're not free to leave. You're kind of being seized there. And then the question becomes, but then is it an arrest? And so you have to do that analysis, even if you're just standing there. But by use of their authority, by use of something that they're doing, they're forcing you to stay there, right? And it doesn't have to be handcuffs. It doesn't have to be at that level. It just has to be in a situation where a reasonable person would believe they were not free to leave. All right. And that becomes pretty clear. I guess I'm hungry too, Carol. I keep using all these food analogies. That's all right. I'll be going to get something here in a little bit. Here we go. The standard is an objective one that, in the context of use of force policy and practice, is often referred to as objective reasonableness, which, of course, we've been talking about here. The objective piece of that is going to be, again, in alignment with an objective law enforcement person. So not just, I work at a grocery store. I used to work at a grocery store. I'm not currently working at a grocery store, but you could come in and say, I'm a cashier. Let me assess the situation and see if this was reasonable. No, we're not. No. Or just a regular person, right? They come in, they say, well, I saw it. It looked like, no. What we need is officers with that kind of training. Would they have done the same thing? All right. So that's how we walk through the difficult road of reasonableness. And that goes also, I can't emphasize this enough. It goes also for doctors. If you're suing other people, you want to look and see, well, was what he did reasonable? Or whatever the job is that is in question at the time. Just have to remember that. All right, number 2, because this standard is not capable of precise definition, that's what I'm saying, or mechanical application, its proper application requires careful attention to the facts and circumstances of each particular case. Now, this is something I think that all of the U.S. is struggling with right now. This idea that everybody else had this road that Mr. Orange had been on, but he's been given all of the detours and all of the, back hills driving, when the rest of us are all like, well, if I did that, I'd be in jail. Or if I did that, I'd be in prison. They wouldn't even do anything. But if he does it, he just go and do whatever he wants. And it's difficult. But one thing we've got to remember is that they do case by case by case. A lot of things, like let's say you've got a judge that does 30, 40 DUIs a day. All right, when they're just going through, boom, 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 get that judge some coffee. But also there's really, each of those people is an individual. Each of those people has their own story, their own fact pattern. And so you have to take a look at that. And it's a heck of a lot of work, but it has to be done. That's also what can kind of take so much time, is that each and every case needs to be assessed in its own right. So here they're saying we have to look at it individually, each case. Number 3 down here is citing the Graham case again. The question is whether the totality of circumstances justifies a particular sort of seizure. The totality of the circumstances refers to all factors surrounding a particular use of force. In Graham, the court lists 3 factors, often referred to as the Graham factors. They may be considered in assessing reasonableness, the severity of the crime offense at issue, whether the subject poses an immediate threat to the safety of the LEO or others, and whether the subject is actively resisting arrest or attempting to evade arrest by flight. So this also, the totality question was just heard by the Supreme Court, I don't know, a couple weeks ago. And they're like, yeah, we need to do totality in this case, because some people were saying you have to assess it at the moment, in the moment. And they're saying, no, let's look at everything. So here, other factors include, but are not limited to, the presence of a number of other LEOs subject to bystanders, the size, strength, physical condition, and level of training of the LEOs, the apparent size, strength, physical condition, level of training of the subject, whether an individual is forcibly assaulting, resisting, opposing, impeding, intimidating, or interfering with an LEO while the LEO is engaged in or on account of the performance of official duties. Proximately and type of weapon, proximate, I can't even say that word. Proximity, there we go. That was a hard one. I need more tang. Proximity and type of weapon present, criminal or mental health history. Oh boy, these are tough ones right here. Criminal or mental health history of the, over back here, subject known of the LEOs at the time of use of force, and the perceived mental emotional state of the subject. So these are a whole bunch of factors. None of them will work alone. You've got to have multiple pieces, and that's what we're talking about with the totality. You can't just say, well, they seem upset. No, we need to have what factors you used. And over time, you get a cop in there, or if you get a cop in there, and that cop's been on the force for 10 years, this is just muscle memory. What is it that you remember that you're looking at? And they'll have different points that they look at every single time, right? Because based off of their experience, those are the factors that work. So every cop kind of sets that out for themselves. So these are suggestions down here. This is in general. Yes, this is in general. We're just looking at the policy, the use of force by the Border Patrol. This is their rules book here. All right, so 2 is done, right? Let me make sure. Okay, the reasonableness of an LEO's use of force must be judged from the perspective of a reasonable officer on the scene, rather than with the 20/20 vision of hindsight. Although, let's be real. Let's just sit and be real for a moment and say, we had this incident occur. We talked about the incident, but then we put it into the report, and then, 7-8 months later, we're in court. So, that hindsight is still going to come in. There's no way to cut it out of your own mind, right? That seemed a violent picture. I apologize. You can't just remove your own hindsight ability. So officers, when they come up to testify, they will have read through their reports. The prosecutors have talked to them, defense counsels talked to them, but they're still people. And if they're up on the stand and they're like, well, this happened and that happened, and they're saying, well, that's something you learn later, right? Like, nah, yeah. But what they want in that moment is a proper assessment. So in determining whether the force an LEO used to affect a seizure was reasonable, courts allow for the fact that the LEOs are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. So that's one of the big pieces as well. And I think that was what Kavanaugh was trying to say, although he didn't say it properly, go figure, is that these are split-second decisions. And with the Supreme Court, and I don't have my picture in here. Seriously, don't clean your desks off, people. Don't ever do that. What I would have to say, if I needed to split the court up based off of empathy or sympathy towards law enforcement, that would be very difficult to do at this point. At this point, it would. Other than Justice Kagan, I think any case that goes through her that is a criminal case, she's gonna, really double check and take a look at. But the others aren't outspoken against police or law enforcement at all. I thought maybe Ketanji would be, but with her decisions that she's been writing, there's no preference in there. So, I know. Why'd I clean it? He couldn't find his words. I agree. We found them for him, though, didn't we, Carol? Oh, my gosh. Sorry, everybody. I think that's funny. Okay, number 3. And then, of course, we're almost done here with this letter that was sent out. We'll move on to ethics. All right, here we go. In determining whether, I didn't put my other glasses on. Sorry, everybody. I'm like, wait, I can't see the words. Oh, here they are. In determining whether the force an LEO used to effect a seizure was reasonable, courts allow for the fact that LEOs are often forced to make split-second judgments. And this is worth really understanding where the court's going to be coming from, right? I know a lot of people are like, oh, we hate all the po-po, or law enforcement. We hate them all. They all are rubbish, right? And, for me, I don't like to put things in definitive terms. So if I am like out and about and have worked with a copper who's been reasonable, like I don't feel that way then anymore. But there are some, when you have this kind of power over other people, that take it too far. And sometimes your training can't push that out, can't block it. It's just something that is a part of who certain people are. And they find themselves like drawn into law enforcement. And then unfortunately come in with some kind of excessive grudge and do harm. That can absolutely happen for sure. Trying to get, I know, same. So we got to kind of keep an eye out for that. And it's rapidly evolving, true, but it's been rapidly evolving crime since the beginning of, civilization. However that civilization started for whomever, if there was someone with a set of books that had laws in them that you had to follow, the people enforcing the law have always had to make quick decisions. So for me, I don't really find this as, well, they had to decide really quick. So did the cave people, right? So did the people riding on the dinosaurs. Everybody's got to make split-second judgments. So for me, that's not a proper excuse, but it is one they use a lot for when they're going around and saying, well, we didn't have enough time. Like, nobody's got enough time, but you still have to do your job. And if you can't do your job in a way that you don't violate the law, then you need to go find another job, in my opinion. And I say that with a flippant tone, but with a serious heart to it. Number 3, consequently, there may be a range of responses that are reasonable and appropriate under a particular set of circumstances. Number 4, once used, physical force must be discontinued when resistance ceases or when the incident is under control. This is what we're missing. This is what we're missing from the law enforcement, from the cubes, which are not really law enforcement. I mean, they're more like, they're I don't know, ticket enforcers. Like you get a speeding ticket or paperwork. That's it, paperwork enforcers. All right, I gotta write that one down. Paperwork enforcers. Oh my God. Oh my gosh. Oh, I'm so funny, everybody. Yeah, self-control, man. Timu law enforcement. Oh my gosh, that's so funny. Oh, it changes with experience. It absolutely does. It absolutely does. Meter maids. I don't think we call them that anymore. But maybe we do. Maybe they do. Actually, trained officers are just randomly hired. I have a feeling right now, because of the situation that we're in, because there's so many people quitting, that they're not being super strict with who they're hiring at this point. And when you are in a situation where the Department of Justice is saying, we just need butts in the seats in the courtroom, that's a bad sign. They just need people to stand up and be like, yeah, I'm here for the government. Well, okay, what's your position? I don't know. And that's what happened to the attorney the other day when she's like, just put me in contempt so I can sleep. Totally understandable. And she's coming into an area of the law she doesn't deal with all the time. And this is super serious. The habeas corpus cases could be some of the most serious cases that she would ever really deal with in court. No experience. It's like, I'm going to pass out. There's nothing else I can do here. And it's hard. It's hard to watch. Agents are being taken off their usual. Yes, they did. Let's see. Changes for people who just want to be mean and violent. I agree, VC. I've not seen a rags to riches story about cubes. All right, I'm waiting. Like, make an Annie story out of it so we understand why you're having some empathy issues. That'd be great. I've not seen that yet. Emotionally regulate should be, well, I agree. Absolutely. Have you ever heard of something like that happening? I'm not sure. Sorry, everybody. I'm not sure what you mean. Crafted by chaos. Have you ever heard of something like that happening? I'm not sure. Let's see. I'm gonna keep watching and see if you can clarify that, because that's a really interesting question. Right, after ICE. That's a good question too, Big Graham. I'm not sure. The attorney asking to be put in jail to get sleep. No. Oh, no. No. In fact, there have been a few situations. I should put one up here on my page. The worst I ever saw of an attorney was an attorney, and it was a traffic crash. It was a two-car collision. And so one owner of the car over here with their lawyer, one lawyer over here with this other guy. So the attorney stood up, because in the beginning we do a lot of housekeeping stuff. We call it housekeeping, right? Well, we make sure everything's set, good to go, know what the timeline's going to be of the trial. He was there with his client, so they're like, okay, we're going to get ready for voir dire, start to pick our jury. So he stands up doing all of this stuff, and he starts like swaying a little bit, like he can't stay still. And the judge is like, all right. And then at 12 o'clock, we'll have lunch. And then at 1 o'clock, we'll bring the jury back in. And he's still just rolling around. And so she started asking him some questions. She's like, so where's your client? And he's like, I'm not really sure. And so they had this conversation back and forth. And then the judge was like, you, sir, are intoxicated, standing in front of me in a case that could absolutely ruin people's lives. And you think that's okay? And his response back was, because he had gotten into a car accident on the way, by the way, to the courthouse. I forgot that one. His car got totaled, and she's like, maybe you should go to the hospital. And, he's like, no, I don't need to. I can play hurt. And this quote, I remember forever. I can play hurt. And then she said, I don't think your client wants you to play hurt. And so when she finished talking, he was like, he was handcuffed and taken from the room. That's really bad. I know, right? Oh, yeah. And not just a little bit too, right? I mean, everybody's probably, partied too hard and coming the next day like, I need to do better. But except for me, I've never done that. And that's that. You can take that to the bank. I've never done that. But some people do. But on the other hand, you can't come in for a full jury trial where there's a lot at stake and be like, I'm all right. No. So that's the worst I've ever seen. Now, with the situation that came out in court just a couple days ago with this attorney who's been fired, obviously, I don't know why she was still there, because a lot of people have resigned. But on the other hand, for whatever reason, maybe she's got a couple of cases that she's been working on for years and they're coming to fruition. And she's like, I don't want to give these cases up I've been working on. So I'll jump through the hoops so I can stay. And that's how I felt. I didn't feel comfortable resigning until I had some of my particular cases settled. So I knew everything was going to be okay when I left. Or not. Who knows? But to stand up there and be like, I don't know. I don't know what's happening. Put me in jail. I haven't slept. I just don't. If you haven't slept and you're talking to the judge, you're going to get yourself into trouble. Never have I ever seen it. I've never seen it ever. So it's so rare. And the language she was using too is so rare to have like that level. Like we have to be respectful when we're talking to our judges. And our judges are people in our community, especially if it's a smaller community, everybody. But our judges are part of our community. And so if you're standing there in front of a judge and you're like, dude, I can't do this anymore. It's not professional, but it's also showing that there's a huge break. So she's like probably on the verge of a mental breakdown, honestly. And I just hope she doesn't stop doing law. That was my other question. She was put in such a shitty situation. She was in such a bad situation. And this is how Abrego Garcia was brought home, was an attorney that got up and said, I don't know what's going on, but this clearly is some kind of a violation. And because he said that, then got fired, then we have the Garcia case, right? Could be mental crisis too. Absolutely. Exactly. And Congress too, in order to make you feel better about Congress, I do go and listen to some of the stuff in the UK. I feel like their sessions are more fun. Like they're like pulling wigs off and throwing them at each other and stuff. Don't get me wrong, New Zealand's hilarious as well, but oh my gosh, yes. So there's something. They had 89 cases dropped on her that week. Holy crap. Holy buckets. That's too many. That's just too many. I've seen firsthand how much attorneys take on and can get burned out, but they've got to fix it. Oh, I know, before it's too late. It's true. It's true. And, as someone with, I think I was at, my highest caseload was maybe 225, and there were multiple children in the case. So you didn't do a separate case if you've got like 9 kids in one file. But where you get to that point where you're like, oh my gosh, I just... one more case, one more thing. And by the time you get to the end and you're standing there, you're like, what just happened? Like you haven't eaten, you haven't slept. You're probably in the same clothes. You're probably pretty angry. So that's not good. It's not good. But yeah, exactly. It's not good. I never wrote, I don't doubt it. And you need to pull yourself off of cases if you know there's going to be a problem, right? I've recused myself on 2 cases in my whole life, and it was because I knew I wouldn't be able to do my job for various reasons. Like one was a doctor, and he just had some kind of traffic issue. He comes into my office and is like, well, we got to talk about this. I'm like, no, you need to leave. And then I was like, recuse. Because he didn't give me stuff that was good for me. He was a bad doctor. Like medical malpractice, that's down the road. So don't talk to me about it. Oh, anyway, the children cases are the hardest. Really, really. Oh yeah. I mean, you can absolutely. Typically, how they say you'll be able to last about 3 years doing juvenile work, and then you're just done. You're able to go back hopefully into a different area, but yeah, and I think that that's very, very true. I mean, just if you're going through prosecuting criminal cases, you're like, this isn't easy. You still gotta get your brain under control. But when you're doing juvenile cases, whoo, it's a lot. It's a lot. She can't recuse herself for, well, that's probably it too. And what are they threatening her with is the other thing. Like, we'll make it so you can never be an attorney again. We'll give you a terrible recommendation. All of your cases are going to be blah, blah, blah. So there's a lot of blackmail material, and I don't doubt it. Mr. Orange is like one of the biggest blackmailers in the country. Truly, he's got so much stuff on people. And if you read some of the lawsuits brought against different people, not just the espionage case down in Florida, but you'll see how he holds on to information so long and will not even deal with anything until you give him what he wants. Yes, and half the Republican Party. And I don't like to pin a party to everyone that's doing things that are harmful. But I mean, we're at a point. We don't have to fake that anymore. All you have to do is look at the harm and who wrote the bill. And I think that's pretty obvious at this point. All right, de-escalation, everybody, which is not what I was doing exactly. To ensure that DHS LEOs are proficient in a variety of techniques that could aid them in appropriately resolving an encounter, DHS components provide use of force training and includes de-escalation tactics and techniques. I don't know about that one. Like maybe do more than just 2 days on this topic. C, use of safe tactics here. And DHS LEOs should seek to employ tactics and techniques that effectively bring an incident under control while promoting the safety of the LEOs and the public, and that minimize the risk of unintended injury or serious property damage. DHS LEOs should also avoid intentionally and unreasonably placing themselves in positions where they have no alternative to using deadly force. Now, lest we forget what had been going on in the Minnesota, this is very important. Like, it's kind of up to you to not stand in front of a vehicle, right? Like, that's a choice that you're making. Exactly. And when you make that choice, certain things happen rather than it turning into some kind of self-defense situation, because that's bologna sandwiches. So here's extra additional considerations. So DHS LEOs are permitted to use force that's reasonable in the light of the totality of the circumstances. So everything going on. This standard does not require LEOs to meet force with equal or lesser force. So your forces get all tangled up in here. Depending on what's going on. You got to look at everything. And DHS LEOs do not have a duty to retreat, which, I don't know, maybe 10 states still have a duty to retreat, meaning if you can run, you need to run to avoid the reasonable use of force, nor are they required to wait for an attack before using reasonable force to stop a threat, which was another issue that we just dealt with out of SCOTUS, actually. Like, do you have to wait until the harm's right there in your face and you're getting harmed? SCOTUS says no. I agree with SCOTUS. So this one time in those 4 sentences. Here's our warnings, everyone. And then we're kind of done here with this piece of it. Thank you. And happy to remind everybody as well that if we can get to 100,000 likes, I do a bonus case. So I've got a fun bonus case today, everybody. It is a landmark constitutional law case, a very important case. So if we hit 100,000 likes, I will go through that case. It's just kind of a case brief on a case you should just know. So I'll just put that out there for you because it's a really good case. It's a lot of fun. I had a lot of fun reading it. That's right. Get the thumbs going. No, don't hurt yourself. All right, let's hit this warning piece. Here are the warnings, right? Now, that's one of the questions that I had in the Wisconsin. I keep thinking of the parade that was run through. But when we were in Minnesota with the woman in the vehicle and they're all screaming different things at her, I'm wondering what exactly they yelled, right? Because did any of what they were yelling fall into the category of what they were supposed to be doing? So let's take a look. When feasible, so it means it's optional, prior to the application of force, a DHS LEO must attempt to identify him or herself and issue a verbal warning to comply with the LEO's instructions. So my question is, did she have any instructions? Different demands. Exactly. Which demands do you follow when you've got 4 people yelling stuff at you? Right? And it's not like you can ask a question like who do what? What am I supposed to do? Which person's the one asking me? I don't know. What am I supposed to do? And so when you've got that, by the way, is lack of training. You need to figure out how to work with your team so that that doesn't happen. And that clearly, teamwork was not happening very well in this situation. Yes, absolutely. Exactly. So this is going to be huge. This will play, I'd imagine, a huge part in whether or not to charge at a certain level, but also in a civil case, which I don't doubt will be coming forward. They do it on purpose in order to overwhelm. Chain of command, very important. I agree. Little man syndrome, want to be, well, I don't know about all that, but here we go. In determining whether a warning is feasible under the circumstances, an LEO may be guided by a variety of considerations. So this is what they need to consider before they start yelling, including but not limited to whether the resulting delay is likely to A, increase the danger to the LEO or others, including any victims and or bystanders. So that's the first one. Is anyone else going to get hurt? Like when he did the pew-pew through the windshield and 2 of his team members could have been also hit because of how the GUN was placed. Hello. Result in the destruction of evidence that I don't know about, allow for a subject's escape, and result in the commission of a crime. So we got to take a look at those. Now, when they say the commission of a crime, there are a couple of ways that they just have done stuff. So we have interference, that's not spelled right, with official acts. With official acts, that tends to be the one they charge because that tends to cover anything. You could stand in front of a popo and that popo can be like, could you move to the side? And you're like, no, I can't. My foot is like cemented to the ground. And they're like, well, here you go, interference with official acts. I wanted to walk in this direction and now I can't. I got to go around you. So now I'm going to give you a criminal charge. That's what this bologna sandwich stuff is right here. All right. I say don't break the law. That'd be great. But also, if you do anything in a situation, it could technically become interference with official act. That's why if you see cops, get out of the way. Hide, people, hide. Love the body cameras coming out. I just love that. I think that's so important, and it's been discussed quite a bit in the legal field for a long time. For anyone that does not have body cameras, and a big thing in my particular state is that our police, our deputies, don't all have them. We might have dash cams, but they don't all have it because, excruciatingly lean on funds, and there's just been no budget for it. So some just don't. Right. Well, that's going to be tough. Although, yeah. They all need them. I agree. So I'm in the Central Time Zone. I don't give away my state because there may be some people getting out of prison that I put into prison. So people don't like it when you put them in prison for a while. And then when they get out, then they get angry too. So I'm kind of in the Central Time Zone here. Yeah, exactly. Montana doesn't have them, of course. Oh, sure. Arizona doesn't have them, just the dash cams. Interesting because this situation, and even going into the next 3 years, everybody, those body cams are so important for the police that are being like, I didn't do that. Like, all right, well, show me. And for innocent people, victims, and even those that they're arresting. a lot of people who get arrested are like, well, the copper really hurt me. It was terrible. And it was awful. And look, I have a bruise, and they kicked me and hit me and shoved me to the ground. And then I say, all right, well, let's back up. What happened before that? And then the client says, well, they handcuffed me, put me back in the back of a cruiser, and I kicked the back window out and I started running. And I was running down. I didn't have any problem. I was trying to cross the railroad tracks before the train came, but they tackled me to the ground, right? So it's like, don't kick the window out, right? That one's a case that was really funny to me. You got to find the humor. Things are a little bit different if you're not doing anything, and many times people are not doing anything. So don't let me do that, but sometimes some people are kicking out the back window. That does happen. Right, don't intentionally. Exactly. And I know it's tough. Everybody, with law enforcement, because we're so quick. We're like, all right, what'd you do? Let's move on. I got more stuff to learn about. Really, no requirement based on the department can afford. Exactly. Do you think so? Well, at this point, Lewis, you're absolutely right. At this point, there's plenty of money for that to be going down. So here's the last piece here, everyone. In the event that an LEO issues such a warning where feasible, the LEO should afford the subject a reasonable opportunity to voluntarily comply before applying force. And I think this is another thing as well. Were they giving her an opportunity to say, do you want my hands up? Do you want me to stop? I mean, did she have a moment where she could figure out which set of directions she needed to follow and what she needed to do in order to be safe, right? There just wasn't that opportunity for her. So I would say this is going to be another huge piece in the lawsuit. New planes. Oh, yeah. What about the FBI's girlfriend? Costs a lot to get. Yeah. And it's an investment. I would agree with that too, Glowing. It's an investment, all of those cameras, but some things that are investments need to happen. It just needs to happen. And, the other thing too is I find it frustrating that the money coming in for the East Wing that's been bulldozed, they're like, oh, we've got these big, huge donations coming in. Like, what? By who? And they're like, well, all these people. Like, okay, I guess these people run the country now. So it's hard to just be like, can we get donations for body cameras? But can they be voluntary, private donations? And then we just don't know. So we're in a tricky spot here because of that kind of bologna sandwich. Oh, we're almost there, everybody. That's so cool. Let me show you here. We'll just dive in real quick to one of these rules in here and see what we can do. All right, so client-lawyer relationship, we got a lot of stuff. Competence, scope of representation, blah, 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 blah. Client with a diminished capacity. It really takes a lot to actually have a diminished capacity. Safeguarding property, which was the one that I wanted to really look at here that we had. Okay. I think this one, candor towards the tribunal. Oh, yes, that's the one. All right, so let's go here to the advocate area, page 96. This is what tells us as attorneys what we're supposed to be doing here, or what we're not supposed to be doing, right? So there's do it, and then there's also don't do it going on in that situation. But this is one of the best rules right here. All right. Now, if you go online, you will be able to find these rules. This is 2020. There haven't been that many major changes. So that's why I just if a change comes in, I'll just write it in as opposed to getting a new book. But this is the Model Rules of Professional Conduct, and it's through the American Bar Association. I'm not recommending buying anything, or I'm not sponsored, but I'm just showing you what the book is. Oh, I hope I don't get dinged on that. Anyway, and when you go inside of the book, you might see just one line like this, like, oh, look, 3.2, expediting litigation. Let's just see what this says. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. So could we think of anyone that does not try to expedite litigation? Just curious. Can we think of any attorneys that might do that? Exactly, VC, you got it. Yeah, so this is a rule that, in my humble opinion, is broken probably every single day by attorneys working at the in the executive branch, right? Right. Well, and that can happen if your attorney's not, the entire DOJ. Some people are like, how do you pick out an attorney? And what I say is, if you're going to buy like a fridge, I know nobody has money to afford a fridge. I get it. But let's hypothetically, if you're going to go out and buy a fridge, usually, maybe it can't just be me, but usually you'll do a little research, right? You're like, okay, the measurements need to be right. The amount needs to be right. It needs to have all the parts that I like. And then you go buy it, right? Same with an attorney. Attorney's like a refrigerator. Is that attorney like giving you all the pieces that you want? Are they talking to you in a way that makes you feel comfortable and not being talked down to? How's the firm? Did you feel comfortable when you went in for the initial assessment? So then at that point, you can say, this is not a fridge for me. I don't like this fridge. And you just hop around until you find one that's the right fit. And it's not always going to be on the first or second try. You're going to have to kind of still go through and sit down, look at them, and talk with them so you can get a feel for it, which I wish we could do with doctors. But for attorneys, you got to do that. You got to find the one that works with you. You're not a fridge. No, Carol, it's good. Well, it's a huge investment to have an attorney. It costs so much money to have attorneys right now, and we know it. We're breaking down how we can reduce rates. That's one of the biggest things in our community of attorneys that we're trying to do, is to make it more affordable, but still make it so that we're not standing in the lines to get the food, right? Because our field is seen as like a really highly paid field. And sure, if you've got Microsoft, but if you've just got Joe Schmo down the road who needs a little help with unemployment, that's not going to be Taj Mahal worthy. You know what I mean? So the reason I go into all of this is to just say, you got to try them out. See if you like them. Oh, did we make it? Oh, we made it, everybody. Oh my gosh. It's fabulous. All right. So, and I'm just going blah, 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 blah this whole time. So the last thing I'll leave you with this, and then we'll go in and dive into the case. Rule, so 3.2, expediting litigation. Anybody? No. Rule 3, and again, one sentence, the rest of the comment, they go in and explain. Rule 3.3, candor toward the tribunal. This is where we can cover almost all of the attorneys, like the New Jersey attorneys that wouldn't step down, the DC attorneys that don't know anything but still have to go stand in front of the judge. They could still be ethically violating the rules by just standing there and being like, well, my boss told me to be here. And the court's like, well, I told you to be here, and that means you need to be ready and willing and ready to go. So Rule 3.3, candor toward the tribunal. A lawyer shall not knowingly, again, they're going to use that word knowingly in order to twist things around, make a false statement of fact or law to a tribunal, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. That's a big one, right? Fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Or, so this just means if you've got case law that says, you've got a client and they steal folding chairs, and it's like, whoa, that's weird. Why'd you steal so many? And he's like, well, I've got like this folding chair situation. And then you find a case that says another man has this folding chair situation, exactly the same. But the court in the folding chair case said, no, well, there's no case here. There's no basis, and tossed the case out. You can't keep that case a secret. You got to tell everybody, like, look, I know this case is out there. And they said people that steal folding chairs, there's really no case anymore, but I still want to argue it. But if you have opposite case law, you've got to just show it around. You can't just, hide your ball there. Tea break. Thank you. So that I think is a really good start. And this couple of pieces right here with the candor towards the tribunal is just very, very important. All right, everybody, let me go grab my, did I grab it already? Our bonus case for today. So just a minute here. All right. Oof, does. Okay. Here we go. Yes. So thank you very much, everybody, for the likes. I appreciate that. Here is, this is a teaching outline I was looking at the other day. When it comes to just the articles of the Constitution, I think that it's very well put together. I may do something for this because we've got every single article listed and what each article means. So I think that's pretty good. All right, everybody, look at this. Look at this. We've got Terry versus Ohio. Oh, I love this case so much. I love it. I just love it. Now, I'm going to just do a quick brief going over it, but the full Terry v. Ohio lawsuit, of course, because this landmark case law is available. I prefer to go to the Library of Congress and get their, and this is where I print it from, rather than some of the other places that, like, I think there's Justia and a few other places you can go, and that's fine. I prefer the Library of Congress. It's a nice, clean PDF, so that's what I prefer. This is the full case here, but let's take a journey here into, cover the case of the lawyer asking to be held in contempt. I'm looking into it, but I'm not sure how much I can get, because at this point, like, I don't have the transcript. Maybe that's posted somewhere, transcript to what happened, but I'm absolutely looking into it here. So, because I think that would really be great to pull the rules out for that one as well. Also, there's got to be, I just don't know how the DOJ's policy is on overtime working or harming attorneys. So I might take a peek into that too, because, it's one thing for attorneys to be like, yeah, let's go. And it's another thing to be like, if you don't go, you're going to get fired. That's in a different realm. So I think we got to be careful with that. Did you see some of it? Okay, well, I'll take a look and see if they're out there, because that would be incredibly important. Saw some content with someone using the transcript. No clue where they found. Yeah, I'll take a look and see. Yes, this is the stop and frisk case. You absolutely got it. So let's take a look, everyone. I love this case so much. All right. All right, everyone. You can call this the stop and frisk case. What I tend to call it is the Terry Pat case. So if you ever hear someone saying, did you do a Terry Pat? They are referring to this case, right? So this, I know, right? So 1967, it was argued, and then the citation's 1968. This is off of oye.org, the Terry v. Ohio piece. I will tell you right now, oh my goodness, everybody, and this is how I know I'm a weird person, is that they have a recording of the original oral arguments. What? From 1967? Everybody, dreams can come true. So 1967, and you can listen to the arguments if you are so inclined to do that. Oh my gosh. Yeah, pretty cool, pretty cool. So we've got the Warren Court here. He's our chief at the time. We name our courts after whomever is the chief justice. So there's the Warren Court, we have the Burger Court, we have the Taft Court. It's called after the chief justice. So here's our facts in the case. Facts right here. Yeah, but that's what makes it fun, Mixed Goddess. That's what makes it fun. When you get someone from the 1960s and right after they started making the movies, right? Like the Gideon case was made into a movie. And so after that, everyone's like Tom Cruise in doing the speeches. Like, put your firebolt down. We're trying to hear. Oh, thank you, VC. Yes, absolutely, absolutely. All right, here are the facts, everyone. I know, squirrels everywhere today. Terry and two other men were observed by a plainclothes policeman in what the officer believed to be, quote, casing a job, a stick-up, because that's what we call that. So the officer's like, these dudes are casing the joint. The officer stopped and frisked the three men and found weapons on two of them. Terry was convicted of carrying a concealed weapon and sentenced to 3 years in jail. So Mr. Terry had one, wasn't supposed to. So here's our question. Here's the legal question from the Supreme Court. Was the search and seizure of Terry and the other men in violation of the Fourth Amendment? That is, of course, unreasonable searches and seizures. You can have a search and you can have a seizure, but it has to be reasonable. How do we know if it's reasonable? It's because we have the court that tells us. That's why. So that's the question. And our conclusion, and again, one of the things I love about Oyez.org is that they tell you how each of the justices voted on it. And that's just really helpful. Excuse me. In an 8-1 decision, the court held that the search undertaken by the officer was reasonable under the Fourth Amendment and that the weapon seized could be introduced into evidence against Terry. Attempting to focus narrowly on the facts of this particular case, the court found that the officer acted on more than just a hunch and that a reasonably prudent man, so this is really where the language comes from, is the Terry case. A reasonable, prudent man would have been warranted in believing Terry was armed and thus presented a threat to the officer's safety while he was investigating his suspicious behavior. The court found that the searches undertaken were limited in scope and designed to protect the officer's safety incident to the investigation. So this is where we get that phrase, officer safety, right? I mean, I'm sure we hear it all the time, but there are a lot of reasons why you may want to do a pat down if you're out in the field, if you really think that they are carrying a weapon. So let's talk a little bit about the Terry pat, like what that looks like, because regular pat downs, you're looking for whatever. So there's all different kinds of searches that you can do, like a search incident to an arrest. And that means, well, that doesn't look right. Here we go. Let me do a different one here. Search incident to arrest. And that means they pat you down before they put you in the car so that you can't do some stuff, right? They can, that's probably the biggest one, I would say. If there's probable cause to believe you have some kind of bad stuff on you, then they can also do a pat. These are not Terry pats. These are not. If the officer is thinking that some kind of contraband or harmful thing is at play here, these are full-on searches that are exceptions to the warrant clause. That's a different that'll have to be a different live. But right? So search instant to arrest. You've been arrested. We're going to search. We're also going to search wingspan area, okay? And then probable cause. A Terry pat is a different animal. First, you're all just walking around, all right? So you're not in your car driving and they're not pulling you over. That's not going to be a Terry stop. By the way, this is legal information explaining how Terry v. Ohio works. Just clarifying everybody here with that. So we're just walking around. You got the dudes over here. I think there were 3 dudes, whatever. And then an officer, a trained officer over here. And he's just looking at the dudes and he's like, they are casing out the joint. And so he's walking over to them. All right. Again, no car at play, no huge, Tommy Guns going. There's just, he's standing there looking at him. So he walks up to them and does a quick pat for weapons only. All right. Weapons only in order for officer safety. That's the Terry pat. Now, this is the legal doctrine of the Terry pat. So a lot of people get a regular pat down mixed up with a Terry pat, right? So we've had before discussions on a reasonable suspicion, right? Reasonable suspicion to believe criminal activity is afoot, and that came from the Terry case, right? So he's walking around, he's like, man, that looks weird. They're all like, one's got a ski mask on, the other one's got a big old bag. This one is like George Clooney. So we don't know what's going to happen here, but I've got concerns. Reasonable suspicion. And so he approaches. When he approaches, quick pat for weapons only, for officer safety only, and determines that there are weapons. So when I say a quick pat too, what's important to remember, we're not getting into pockets here. We're not getting into places that only your doctor can go. No, 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 no. A Terry pat is not a full pat. It's quick outside clothing, like boom, 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 boom. Like pockets, checking pockets and where a weapon could be, a lethal weapon, right? So that's very important. They're going pat, pat, pat. There's no, and this is what my... Oh my gosh. So in law school, this is what my professor would say. There's no massaging. All right. There's no like, ooh, what's this? What's that in your pocket? No, that is not right. That could be this kind of search. Terry pat, no massaging. All right. Don't get too friendly on the pat. It's quick. If you linger, your Terry pat might turn into an unlawful search. All right. Move those hands. Keep them moving, because if you don't, then it goes into a higher level and you need to have probable cause. And if you've only got reasonable suspicion, you don't have probable cause, things are gonna get crazy. All right. Now, what can happen, as a quick side note too, just pat, that's right, patting it around. Don't threaten me with a good time. Right. But here's the other deal, though. Let's say in this situation, the copper's like, quick pat, and then finds out, like, not squeezing, but like this one's got this huge water bong, right? Now that's not okay in this jurisdiction. So, and it's in his pants, right? So that's how he's walking around. So this dude, the copper's like, based off of my years of experience, I'm just doing a quick pat, but I think we got a bong in here. So what does he do? At that point, reasonable suspicion turns into probable cause, because that's pretty significant if you find a bong in somebody's pants, right? And so probable cause now will get him into the pocket or wherever that bong is. I'm going to have to change my stories these days. Oh my gosh, I'm going to have to change this up. All right, well, whatever. So no massaging, no squeezing the pockets. But if your hands land on something that is clearly some kind of illegal, whatever, now you've got probable cause going to the pocket. All right. But you got to feel it from the outside first. You can't just straight go in the pocket. All right. So that again is what distinguishes a Terry Pat from all other Pats, literally just for safety, so that the cop can talk to you without being worried that you're going to pew pew him. All right. So a lot of people are like, officer safety, ha ha. But it's true. That initial, discussion. The other thing too is that everyone's walking around, so we're not in a vehicle. We're not inside of a place either. We're just walking around. The officer has no way to know if these three are going to pull a weapon on him or not, unless they get patted down. Now, if you use racial profiling, which is the Kavanaugh stop, that's not going to be enough for a Terry Pat. So if they're down here with a reasonable suspicion and they're like, you can racial profile all you want, you're still going to need more than that. You're going to need some other stuff at play in order to get that Terry Pat justified. So that's something else to think about. It can't just be because you're brown. Like, oh, you're brown, I'm going to walk up and do a pat. No, because later on, when we challenge that in court, you're going to have to show me what your reasonable suspicion was. And brown is not going to carry you past the finish line on that one. All right, so there you go. There's my whimsical take on Terry v. Ohio. One of my favorite cases because it sets the rules. It sets the rules as we go through the rest of the cases where we're doing pats and stuff. Just remember, holding that for a friend. Don't, if you're going out to do bad stuff, I wouldn't take certain things with you, but so what were they? That I don't have here, but I do have, it's actually in the case if you want to take a look. Oh my gosh. And again, this case is really interesting. So he approached and he was like, hey, what's your names? And they're like, blah, 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 blah. We're not going to tell you. So it really got into some interesting groundwork. Right. It's somebody else's. Carol. I mean, obviously, that's not a good choice. You have already been probably using that too much if you're already putting it in your pants. I mean, hiding it in your pants. Yikes, I'm going to get into trouble. All right, everybody, with that, now we've got the Terry v. Ohio case. So we're just putting them all together. Every single, probably wasn't. Oh my gosh, I'm getting in trouble. Getting into some trouble here. Oh, I'll try to be back later tonight, everyone. Hopefully I'll be able to get those transcripts. And I'll have to do a full live on that because that's really amazing, that whole situation. So I will say fare thee well at this point for our lunch and learn. Thanks for coming and hanging out. Thank you to the moderators. You're amazing. I am so thankful to you. Yes, we got to watch the Terrys. Watch the Terrys. So I will see you all.